The Institute of Public Affairs recently received legal advice from leading Victorian barrister and constitutional law expert Mr. Stuart Wood KC about the lawfulness of the referendum to create an Aboriginal and Torres Strait Islander voice in the Australian Constitution. Mr. Wood's advice is that the referendum question misleads and misinforms voters, has a serious deficiency, and could therefore put the validity of the referendum itself in doubt. Section 128 of the Australian Constitution requires the Australian people to approve any proposed changes. According to Mr. Wood's advice, this means the referendum question must accurately reflect the proposed change, and that the referendum process must allow electors to exercise a free and fair choice. The key problem with the forthcoming referendum on the voice is that the question that will be put to voters is misleading. The referendum question describes the proposed change as one that will recognise the First Peoples of Australia by establishing an Aboriginal and Torres Strait Islander voice. This provides no information about the role and function of the voice and disguises the content and scope of the proposed new Chapter 9 of the Constitution. Only the introductory line of the proposed change to the Constitution mentions recognition, whereas the substantive terms of the proposed new Chapter 9 of the Constitution all relate to the scope, powers and role of the voice. This includes subsection 129(3), which makes Parliament's powers to pass laws in respect to the voice subject to this Constitution, meaning the High Court of Australia will determine the scope, powers and role of the voice. Mr. Wood concludes that this misleads and misinforms voters and thus makes the referendum open to challenge in the High Court of Australia. The advice also states that the Constitution requires the referendum process to be fair, so voters can make a free and informed choice when voting in the referendum. Mr. Wood believes the ability of voters to make a free and informed choice has been undermined in this case because of unfair public funding for the Yes and the No campaigns, unfair tax concessions granted to the Yes campaign, and the absence of a constitutional convention. The fact that there are constitutional doubts about the validity of this referendum is a result of a flawed process adopted by the government from the beginning, in which they have pushed a certain version of the voice regardless of the consequences. IPA research has shown that the parliamentary committee that reviewed the referendum was biased and flawed. 94% of all witnesses invited by the committee to give evidence were already in favour of the voice. At the highest levels, there was no real debate and glaring legal issues were overlooked. The government must ensure that this referendum is a fair one. At a minimum, this means that the referendum question must include the full wording of the proposed Chapter 9 of the Constitution, so voters know exactly what they are being asked to approve. It is only 112 words long. There is no need to summarise it. Any attempt to do so simply misleads the public. For more information about the IPA's research, visit www.ipa.org.au.
Authorised by Scott Hargraves, Institute of Public Affairs, Melbourne.